panel discussion. My name is Elena Lunyova. I'm Advocacy Director of the Zmina Human Rights Center, and our third panel will be dedicated to the victims. And I will be moderating the most human-centered panel. And we will be talking about how the state supports those who are the victims of the armed aggression, and how we'll discuss how can we talk about non-repetition guarantees and what we are supposed to do and what we are doing so that the victims of international crimes and war crimes can seek justice and can be supported by the state in a proper way. And I'd like to invite Ksenia Hetz, head of Right for Protection Project, Mikhailo Kamenev, Senior Project Specialist of the Register of Damages to Ukraine Kyiv office, Inna Zavrotko, Department of Legal Support of the Ministry of Defense of Ukraine, and Yulia Likhach, Director of the High School of Public Governance. And later on, Veronika Plotnikova will join us, head of the Coordination Center for Victims and Witnesses Support of the Office of the Prosecutor General. And I believe that we mentioned Prosecutor General Office today in multiple occasions. So, ladies and gentlemen, we will be talking about how the state, as well as non-state actors, are protecting the rights of victims of the war. And Ksenia, my first question goes to you. Can we say that Ukraine has the system for supporting victims of armed aggression? Maybe we don't even have such system in place. And how can we describe the way the state protects the victims? Thank you so much for having me here. I'm gonna first ask a question of the audience. Do we understand who are the victims of armed aggression? There is an act of legislation that mentions it. The definition of a victim of armed aggression is not in place. And it's been 12 years since the war broke out, and when we're talking about the support system for the victims, we don't even understand who they are. And I think that this is one of the key things worth underscoring. Next thing that I'd like to mention, and what Roman Romanov said really resonated with me, who was talking about incapable institutions and incapable procedures. I believe that the cause why we don't have the comprehensive victim support system is that we have institutions that lack capacity. And now I'd like to mention what started in February last year, because we'll remember that in February last year, the Ministry for Integration that basically is responsible for the rights of victims, internally displaced persons, and residents of temporarily occupied territories. And now we are not assessing whether they did a good job or not. We're just saying that it was within their scope of responsibilities, and they were responsible for implementing it. So in 2024, 3rd of December, this ministry dissolved and it turned into the Ministry of National Unity. Then a few more months passed, 7 months to be more exact, and our Ministry for National Unity disappeared and was transformed into the Ministry of Social Policy, Family and Unity. So basically today, there is no central executive body that is framing policy dedicated to the protection of victim rights. It is simply not in place because part of the powers that pertain to protection of IDPs, internal displaced persons, and residents of temporarily occupied territories was transferred to the Ministry for Development of Communities. The civilians who were harmed and injured as a result of a war are within the scope of responsibility of Ministry of Veterans. The people who were detained are within the scope of responsibility of Ministry for Development, and internally displaced persons is something that the Ministry of Social Policy is responsible for.
So when we talk about the policy for protecting the rights of victims of armed aggression, there are a couple of central executive government bodies that are responsible for that policy, but in reality, they don't cooperate, they don't coordinate, and they're following their own track in their efforts. So if we try to respond whether Ukraine has a policy or a strategy to protect the rights of victims, no, we do not. There are these pinpoint solutions implemented by the Ministry of Social Policy in the context of protecting the rights of IDPs, partially implemented by the Ministry of Social Policy. The ministry supported the adoption of the law 4071 on accounting for all the information, registering all the information on the damages. There are also efforts on the protecting CRSV victims. Along some lines of efforts, the Ministry of Development introduces some initiatives related to ensuring housing to the IDPs, as well as the veterans and individuals who are wounded as a result of the war, as well as the residents of the temporarily occupied territories or IDPs. We have the National Compensation Procedure 2923. But all of these are pinpoint efforts, right? They are not systematic. They do not ensure a comprehensive system for the support of victims and survivors. They do not give us an answer to the question who victims are. When we go back to the law 4071, this is a very important law. When we go back to that law, right? It is an important law. And I'm grateful to Mikhailo himself, because him and I, we worked together. We were part of the working group that was doing such an important thing. We were trying to preserve and document and systematize all of the information on the damages to non-property rights. The Article 8 delineates 16 categories of damages to non-property rights. The closing statements envisage that over the course of the months, there would have to be a draft law developed in the support of victims, as well as the implementation of amendments to the current legislation to correspond to that law, and the local self-government bodies were responsible for documenting that information and basically accounting for all of these individuals. Has been more than a year, because 4071 was adopted on November 20th, 2024, and nothing happened. Not a single thing. We don't have neither a system nor the actual law. Furthermore, the Ministry of Social Policy, Family, and Unity, in their draft program for the government, did not mention this law, did not mention any measures on its implementation. So to me, it feels like there is no system to support the victims. And if we go back to Law 4067 on the legal support of individuals who've suffered from CRSV, there's a law, right? It envisages immediate financial compensation, intermediary reparations. But at the same time, there are no supporting legislations that were developed to implement it, and nothing is being done over the course of last year to implement this law. It is through the Global Survivor Fund that certain support was provided to 548 survivors of CRSV. There were 3,000 euro of compensation paid to them, but that's it. Nothing else happened. And the same thing happened when it comes to the individuals who suffered illegal detention. The law is very much fragmentary, and it does not cover the civilian individuals in temporary occupied territories that were illegally detained if that was not somehow related to their civil society or political activities. Thank you, Ksenia. I think it's very important to mention the fact that we don't have a victim and survivor support system. We have these pinpoint activities and efforts, and some of them are more effective than others, but a system as such does not exist. Even still. And since you mentioned the accounting for non-material damage caused by armed aggression that was never fully implemented, I think it will be quite logical to build a bridge toward the actual damages that are being accounted for. And Mikhailo, I do have a question to you related to the fact how willing are the people to submit information on the damages caused by the armed aggression? If there are any differences in the type of damage suffered, and you could share the difference, please do. If there are some things that people are more willing to report on than others, I'm not going to mention the compensation commission because I think that it is still related. How often people report damages is related to how realistic it is that they would get the damage compensated. However, if you do have any updates on that, please share those as well. Thank you, Alana. Thank you to the organizers of the event, and thank you all for joining. I represent the Damage Registry for Ukraine. It is an international organization that operates in the institutional framework of the Council of Europe that was created based on the extended partial agreement of the Council of Europe. And until December 16th, we are actually looking forward to a diplomatic conference at Hague where the Council of Europe Convention will be signed that establishes the International Compensation Commission for Ukraine. And this commission will actually include our damage registry. It will become a part of the commission sooner or later and will dissolve in the compensation commission system. Compensation commission is the second step towards implementing an international compensation system. The first is the registry, of course. We account for the statements on the damages suffered as a result of the armed aggression. The second step is definitely the establishment of the compensation commission that will decide on allocating compensation to individuals. And the third stage will be the actually payments of those compensations. There will be a special fund that will implement these decisions. It sounds simple, but it is not, because there will, of course, be an issue of finding the resources to pay for those compensations. It is clear from the get-go that we are not talking about paying compensations from the funds of the government of Ukraine or our European partners or anyone else, because compensation envisages covering the damages caused by the perpetrator. The perpetrator here is clear. It is the Russian Federation, and the framework of the Council of Europe, it is clearly defined. And the organization of the Council of Europe is acting within the framework established to hold the perpetrator, in this case Russian Federation, accountable. So we are well along our way towards establishing a real operational compensation mechanism. The claims that are being submitted right now through DIA, through the web portal DIA, the claims can be submitted by anyone and everyone. It is free of charge. You don't have to have any type of legal literacy to be able to do that. However, at the same time, it is the procedure that requires certain proof to be provided, certain evidence. The register is a non-judicial procedure, because the previous panel mentioned judicial procedure. We are talking about administrative procedure, right? The legislation pieces that were mentioned by my colleagues before me are also pertaining to the administrative procedure. So the burden of proof is much lower. There have been more than 75,000 claims submitted to the compensation mechanism. You'll ask me if it's many claims or not. It's just the real number, and we are expecting more claims to be submitted. We don't know for sure, of course, what is the reason, which we will study, but we do not know why there's 75,000 of those. I think people are concerned by the lack of real possibility to receive compensation tomorrow. They don't have a clear understanding when would they get the funds. Our assurances and the assurances of the international community that the compensation will come, the only issue is when, are not enough, of course. And in this context, the work of our national partners is crucial. The government bodies, the civil society entities that within the framework of this registry are unified in a coordination platform on advocating and raising awareness about the registry amongst the widest range of claimants, and to understand categories, right? It's not that one category is more popular than the other, or some people are more willing and some people are less willing. No, instead we see a significant correlation between the work of civil society institutions and state government bodies in certain area with the number of claims. We see that A large percentage of claims are the claims of relatives of the missing persons, and we relate that to the efficacy of the work of one of the organizations that works with the families of missing persons. On the other hand, we see a very low number of claims of individuals who've suffered from sexual violence, and as of the third quarter, there have been 110 or 107 of those claims. It's not that many. Take into consideration the fact that the criminal proceedings mention more than 330 victims of CRSV, and the Global Survivors Fund pilot project had more than 1,000 CRSV victims submit their claims. Maybe some of them pertain to events that happened before 2022. However, 70% of those claims pertain to events that took place after. Even though we have organizations that work with CRSV victims, we are still expecting them to assist their clients or customers to submit those claims. We are also counting on the efficacy of government entities, because compensations, they would be provided to Ukrainian citizens, right? So from the viewpoint of the reparation process itself, it is important because that money will be eventually invested in the Ukrainian economy. So it is logical to expect that the government has to have a vested interest in raising awareness. And even though the draft law or the law on CRSV is not a part of the government program for next year, the register was mentioned in it. And one of the KPIs for the Ministry of Justice for next year is raising awareness about the damage registry. And we are starting to be mentioned more actively by different government bodies. And in a recent presidential decree from November 27th, it contained multiple proposals related to children, but one of the paragraphs there was actually an order to the Cabinet of Ministers to consult individuals on submitting claims to the Register of Damages. So we implore all of you to join our coordination platform to raise awareness amongst victims and survivors and help them submit claims, because even though it may be easy, sometimes it is quite difficult for the people who survived atrocities. Thank you. Thank you, Mikhailo. There are definitely mechanisms for accounting for these damages, even at the international level. Even though we don't have the national level yet, the National Registry should have taken into account all the damages suffered since 2014, but the existing registry does not. So it is very important that we have to implement also the complementarity principle, because Ukraine at the national level has to mention 2014 more. Maybe eventually the international register will also account for the damage claims since 2014, but for now the national register has to fill that gap. So we mentioned that we don't have the system, we have to build the system for the protection of victims and survivors, but the construction of this system depends on how cognizant, on how professional would the people building that system be. So my question is to Yulia right now. It pertains to education, but professional education, I guess. Professional education of public servants, and the question related to which extent, when we are talking about justice and accountability, how much the individuals involved in building the system for protecting victims and witnesses should be cognizant of the issues of transitional justice. Thank you. I can reflect on the previous statements by previous speakers. And we've started working on CRSV issues and victims and survivors issues since the beginning of the war. The first program that was developed for public servants was the program on CRSV, to make sure that there is a unified approach to training public servants on the national and local level. We understand that the issues of working with victims and survivors, the issues of social services, and I constantly mention this as a representative of the higher school of governance, these issues have to become the cornerstone of the work of all government institutions. Our government, our state has to be human-centric in order for people to stay here, in order for people to come back here, in order for people to feel like the government cares for them. What does the High School of Public Governance do? Well, we work with many government institutions, first and foremost, and I feel like a great victory of ours, or maybe a great achievement of ours over the course of the past 3 years. And the achievement of the state agency, is the achievement of my team, the civil society institutions, is the fact that the government bodies started to implement training programs with us together. So when government bodies approach us and say, hey, we have this policy or the other, and we would like to make sure that other government entities are aware, this is something that we've been working on for 3 years already with the National Social Service related to social security, to gender-based violence, to CRSV. The employees of the National Social Service and us, we are all cognizant of the fact that not all policies that were developed are developed properly, because we know that our CRSV law had to have complementary legislation amendments be developed, but it doesn't mean that we stop. It doesn't, and I know that it doesn't all depend on all of the employees of different government entities, including the social service. It's not only their responsibility. And even though I'm working on the other side of barricades in the civil society right now, I know that in the government there are a lot of people who take it close to heart, who want to improve these policies, and I see that we conduct a lot of events for different government service entities, for the centers for administrative services, and 70% of those employees are women, and we know that they really want to help the citizens that are approaching them. Sometimes they lack knowledge, sometimes they lack strengths, and sometimes they lack the moral support, because we are all humans. And today, a government employee can also become a victim at any point. We are all currently being targeted, and we could quickly transfer between these categories. So conducting these awareness campaigns cannot just be theoretical campaigns, right? We are trying to make sure that all of our training events are very practice-oriented. I'm delighted by the fact that the Ministry of Veterans approached us with their training programs, asking us to develop programs and curricula on assisting veterans, because they are in charge of developing veteran policy, and no one knows better than them how to do it, right? So this year we've trained 600 government employees and public servants on how to act with how to work with veterans, and those were the training events targeting the employees of the centers of administrative services who primarily work with veterans. And I would like to also thank the representatives of civil society organizations, the Ukrainian Helsinki Human Rights Union, because we are on the same side of the barricade. We are a part of the same mechanism, and the more we assist each other, and the more we critique each other, which is also normal, but the more we assist each other, the better results we will achieve together. These initiatives are great for that. In terms of the damage registry, the employees of the damage registry are often instructing at our training events. Just last week, we have had a training for the health department employees, and you were there. Today, we've started the training event for judges, and your representatives are present there as well. We had a training for the heads of the regional state administrations, and we also included the awareness issues into the training. We had a huge training for the local government body representatives as well this year. So these training events, they have to become a large-scale instrument. But it's also very important for me to make sure that we have a shared vision, just to make sure that we are not doing our own thing, because the thing is something that we have to come together under.
I'd like to express their gratitude to the representatives of the State Archive, Tatiana, who is also one of our trainers, because oftentimes public officials come to us and they are saying that we are willing to help, we're willing to train people. And it's not only about training, it is also about sharing knowledge. It is also about sharing experience. That is why I can tell that there is still a lot of work ahead of us in the future. a lot of work. And what am I trying to encourage you to do? To unite the efforts of the mass media, public authorities, civil society organizations to help the victims and our entire state. We're also now working with the military, and protection of civilians is also part and parcel of this effort. In high school, we are open for cooperation. I'd like to once again express the gratitude to the Ukrainian Helsinki Human Rights Union, and especially if there is a top-tier public official saying very proper thing. For example, we had training in transitional justice in Borodyanka this year. Remember, when public officials of the top tier didn't want to leave, we were done with the training, all of them stayed back because it pains and hurts each and every one of us. Now we're not talking about different things. We're rather talking about how do we protect our state. Thank you so much. Thank you, Yulia. Well, I think that there is one problem, that we can teach people very proper things, but at the same time the state might do something that's not the best thing. Same as legislation dedicated to collaborationism, which Romanov mentioned. And it also comes along with some challenges. Well, this is a very complex topic. We also are trying to very carefully approach it. And this topic is, it's pretty complex on all levels. It is very important for the state to not make any unexpected moves and to make some decisions that are going to be mandatory for everyone, which will result in dissonance. And when you're talking about international experience at all the events, I keep saying that international experience is very important, but Ukraine has a lot of our own experience that we should take into account. But at the same time, there are also certain framework of the right, human rights, international humanitarian law. But there are certain suggestions about how it can be changed. So will there be a new Geneva Convention or maybe a new additional protocol that will be added to the already existing Geneva Convention, Protocol 4? So where are we headed? What is the position of the state when it comes to the situation on this track? Thank you. Thank you very much. And a huge thank you to the UHHRU. Hi everyone. It is a pleasure and joy to be representing the Department of Legal Support of the Ministry of Defense of Ukraine. Therefore, as a representative of the state body, later on, I might also mention some things not as a representative of the Minister of Defense. But coming back to your question, actually, human rights and international humanitarian right are not excluding one another. This is the groundwork that is known to all of us. But this is something that we should always keep in mind and talk about. And oftentimes, international humanitarian law is called in a different way. Some people say that it is slightly outdated. Sleeping Beauty. So there are different versions, but what they say is that international humanitarian law is slightly outdated and it cannot exactly cope with all the challenges that we are faced with. And if we're to be objective, we could say that there is a share of truth in it, because there is a huge gap between when all of the international humanitarian law was compiled, because 4 Geneva Conventions were adopted in 1949, and a lot of time has passed until the present day for everything to stay as it used to be. Because in 1949 there were no drones, there were horses. Now we have cyberspace that we didn't have back in the day, and many other things. That is why my main message is not that IHL is bad or very outdated. It is also about how the armed hostilities are evolving, which requires quick decisions from the society and the state to respond to them. From this angle, does IHL need to be updated? Yeah, and it would be great to have some clear norms that would contribute to that. Now, let us look at it from the practical point of view. Are we geopolitically in a position when we can behave like how did you say the New Geneva Convention or additional protocol to it? I personally think that no. And this is the objective reality. Because geopolitically, we are not ready to now talk about new international agreement that everyone is gonna sign and stick to. Does that mean that we are supposed to just sit down and wait? No, because there are many other tools that can be used. Bilateral tools, multilateral tools, do something for some rule, become more of a customs, and then say that it should be applied, and many other mechanisms, including regional organizations, including regional security organization. So what is Ukraine doing as a state in this regard? To be fair, and I am a big advocate of the state, Ukraine as a state is doing a lot. And I probably will not have enough time to mention all of the things. But for example, our experience is very unique. No one has built such a comprehensive system of treating prisoners of war. None other state in the world, none of other states is discussing the need to develop new approaches to application of international humanitarian law at international level. We're saying that the norm that exists can be implemented in different ways at the national level. The mechanisms may be different, the tools might be also different, the one that you as a state develop, and many, many other things. That is why we need to focus on that. And we are, in fact, focusing a lot on it. For example, MOD has the unit of legal support, and all of the groups of people that works there are amazing individuals, and they have very clear-cut approach. IHL has to be practical, and we need to talk about practice without theory, because IHL is applied on a daily basis by every single serviceman and servicewoman who is on the front line, period. On a daily basis, IHL is applied by public officials of local government that are located in the areas adjacent to the front line, and many civilians who continue living to the seemingly peaceful cities and towns in Ukraine are also applying IHL, even if they are not aware of that. That is why the practical approaches do not require any amendment to the IHL, but they require changing the understanding, application, and implementation of IHL at the national level and local level. There is an amazing initiative by the Ministry of Foreign Affairs, a platform dedicated to development of international humanitarian law. And despite all the skepticism, I personally also have sometimes I am wondering whether we can change IHL. We need this platform because it records best practice, because they can clearly say that we have a gap here and we did this and that, and we believe that this is a really cool thing. So maybe we can turn it into the new norm, and we could also share this experience with other partners and look for the ways to further disseminate this idea at the international level. And I'd like to say that all of the international events that we participate on behalf of the Ministry of Defense, they demonstrate high level of hunger, very voracious appetite. And it has to do with defense, many other sectors too, by the way, because unfortunately, nobody in the world has the same experience as we do, and no one can do that in such a heroic, resilient way. And finally, I would like to mention that I would like to suggest looking at IHL as a tool that can be used in a really cool way in different contexts. And I cannot help but remember the peace talks that were happening in Istanbul in summer 2022 when two parties, Russia and Ukraine, with the participation of third party, we'll know who the third party was, came to try and join some agreement about ceasefire with absolutely different positions. When one party came with a memorandum to share it and the other one didn't. So these are like approaches from two different universes. And the only thing that these people managed to agree upon were the things that are regulated by the international humanitarian law. POWs exchange, repatriation of the bodies and remnants, and a return of Ukrainian children. For me, that means that IHL and the humanitarian sector, well, let's be realistic. I also am trying to be a positive person. IHL is a tool that the state of Ukraine, the civil society, can apply to build dialogue. It is not about just agreeing and everything working out perfectly well, but it is about the doors that used to be completely closed, locked up, and no one had the key from that look, suddenly open slightly. And the parties managed to reach at least some agreement. That is why IHL is not simply an area of law, but also it is a tool that provides political and other benefits to reach the goals that we are setting for ourselves. And one more quick comment, because it pains me. Now, I am not the representative of the MOD. I'm speaking on my personal behalf. Maybe I have some psychological issues, but it triggers me so much when people say, well, the state is doing this, the state is doing that, and every single time it hurts me so much, because in my universe, I'm part of the state. Every time someone says that the state hasn't done this or hasn't done that, I'm thinking, oh, I haven't done it. And that it affects me personally. So I'd like to make two statements in my personal capacity. Do not generalize. If you are talking about some specific individual, just say their name, because all of the public officials who are responsible, they start taking it very personally, and we don't need additional mental health problems. And one more comment that I'd like to make is also another favor I'd like to ask for, and my colleague has mentioned that. I'd like to thank Yulia for that. I believe the power of a fist. And in Ukraine, we can have the strong fist only if we have properly coordinated effort of the public authorities and civil society. Otherwise, we're not going to have this proper fist. That is why it's okay to criticize one another. It's cool when this criticism is constructive, but if you are criticizing, please make suggestions. And I'll be really glad if, as a result of today's event, these ideas where the public authorities are not exactly showing the result that we want, you also develop some recommendation that you will be submit to all the authorities. Trust me, that's going to be a very good outcome. And public officials are going to be very grateful and appreciative. Thank you. I believe that there are very few NGOs and CSOs outside of this room who are doing as much as we do together with the state. So, yes, we accept your comment, but everything that the civil society organizations are offering in the domain of transitional justice, I don't know if there is anyone else who suggests that. It is just necessary to have a recipient on the other side who is willing to listen to us. But say if we have an institution, but all of the authorities have to do with transitional justice or victims are slightly lost in the transfer procedure, then it's slightly difficult. But thank you about this IHL overview, because Oksana, during the first panel, mentioned how journalists are perceived as the competence, if they're willing to use drones or if they're trying to use EWs. And this is also very important for the humanitarian actors. And I think that question number one that I would like us to focus on is, what do you do with the humanitarian actors who participate in evacuating civilians from the battlefield if there are drones that are aiming them? And what if they want to use the EW? They will be refused to do that, because they'll say that if you start using electronic warfare means, and if you're using jammers, then it means that you're not a humanitarian actor anymore. And I think that it also has to do with application of the IHL norms and rules. And the war today is not the same as war 30 years back or 50 years back. But in the meantime, Veronika Plotnikova also tiptoed here, the head of the Coordination Center for Victims of Witness witnesses' support of the Office of the Prosecutor General. And Inna was mentioning that during talks with other players, they were talking about people who are civilian detainees, prisoners of wars, returning the remnants of the bodies, and returning children. If we're talking about deported children, if we're talking about civilian detainees, if we're talking about bringing them back, these are people who are victims of international crimes, war crimes. And these are the people who unfortunately receiving the least support from the state. And there is no specific category of aid and assistance to such victims. So the coordination center is basically that entry point that can support victims. So Veronica, could you please tell us about how you operate and what challenges are you faced with? Thank you, Alona. It is a pleasure to be here among all of you, especially among these distinguished panelists, because we have been cooperating with them for quite some time now, I'd like to say. And actually, Ksenia said many things that I was about to mention, that there is no status of the victim, but there is a status of a survivor. But it doesn't give you rights to access services. It only gives you certain responsibilities to be part of the criminal proceeding, clearly to testify, but this has to do more with the witness probably. And I would like to do the overview of why did that even appear. Could you raise a hand if you're thinking about the prosecutor's office? If we're talking about that. Oh, wow, Stanislav. Well, Stanislav, we know that you are affected by your own personal trauma. We can discuss it after the event. But let me be frank. We applied very practical approach. Well, this is not a new model. This is not something new from criminal justice in general. And now everyone started to actively study in the EU directive about the rights of the victims. It also mentions the need of providing access to support services. And spoiler, it works in many countries. But when we started working on it here, we came across many denials, but again, this is my personal trauma. So, what did we see? Mass victimization. Today, Stanislav and many other people were talking about the number of criminal proceedings. And for example, in one proceeding about Bucha, we have a few hundreds of victims. And stories that pertain to mass shellings are dozens of people. And aside from them, the secondary victims are their families. And we also realized that a victim is not ready to work with the system of the criminal justice. They are not willing to deal with this machine because it hurts them way more than a possibility to just reflect on it on their own. Moreover, we realized that people are lost and confused because we also were lost and confused in 2022. No one was prepared for such huge volumes. And we didn't know how to digest all of that and realized that there was a huge need. People want support and help, and there is actually... Okay, I'm going to put in a number. Well, we cannot yet call it a system. Number of civil society organizations that are willing to work with the victims. But what we lack is bridges and awareness.
Because I can't really tell you that communication is the queen of all sciences because I'm closer to philosophy or math in that sense. But communication is the foundation of system building. And that's when we started our efforts in that regard, and we created this unit. At that point, it was a really small unit. Today, it is a system because we are operating both in the Office as a Prosecutor General, and also my colleagues are working in the 9 frontages and in the occupied oblasts of Ukraine. And you are the first to learn that we have officially confirmed 3 new sections in other oblasts of Ukraine where we have a large number of IDPs and where we have this proximity to the border. And what we started to do? Well, we started to assist primarily the system itself to work with victims and survivors. My colleagues have different background in terms of training, but all of them have gone through the standardized training on case management, social assistance, primary psychological aid, because they have gotten access to their positions through open competition, and they have had different backgrounds. Of course, I have 3 people who joined our team right after graduation from their master's program, and yet the team shows tremendous success. And we also have people who have joined us at a point in their lives where they could have been retired, but they still came back to work because the victims and survivors are different and they require different individuals to reach out to them. So what are we doing right now? Well, we are building these bridges. We are structuring a long-standing resilient assistance to survivors. Prosecutor's office is not an entity in providing services, but it is an entity in bringing people together. So our first task is building internal communication, communicating to victims and survivors the realities of law enforcement and how, in simple words, we explain what the prosecutor was trying to say, what the summons and pamphlets mean, because often when the prosecutors reach out to victims, they feel like they are being arrested. Yeah, but that's true. Okay. Please raise your hand if you've had pleasant memories. If you have encountered the system of criminal justice, or even if you have not, please raise your hand if it makes you feel the system of criminal justice makes you feel comforted. No, but that's true. That's fair. But as you see, we are trying really, really hard. But the second thing I wanted to mention is the evaluation of the needs and being able to address those needs. And I'm usually really tired at the end of the year, but I will never be too tired to express my sincere gratitude to our colleagues from the NGO sector, because our civil society colleagues have been extremely committed to our cooperation. But I also want to thank a large number of my colleagues from state institutions. Of course, state institutions lack a systematic government policy aimed at assisting certain categories of victims of war and international crimes, and they also lack an understanding of who are these people, what is this population affected by the war. Yeah, we do have those issues, sure, especially in a situation where we ourselves, as the representatives of state institutions and agencies, we are also the population affected by the war. And it is extremely complicated when you yourself have your arm broken, but you see someone have their back broken, and you have to still try and help them. So we have established this referral mechanism that we are operating through. We are currently have more than 70 organizations that we work with. Some of them work all across Ukraine, and some of them are regional in nature, because, spoiler alert, not everyone works in Kherson, but there are people living in Kherson, and there are my colleagues working in Kherson. And when we mentioned electronic warfare assets, we can be perceived as combatants, yeah, because we are riding through Kherson with EW assets. Without EW assets, you will not survive driving through Kherson. In my unit, 3 months ago, we've lost a vehicle. We haven't lost people, thankfully. But the safari, where the Russians are trying to attack civilians on purpose, is their modus operandi. And the third thing I wanted to mention, it is even more large scale, and it pertains to something that may sound pretentious, however, I will mention it, is expectation management. This this expectation management, the expectation is from the government, from international institutions, and developing realistic expectations, because as Mikhailo mentioned, talking about the damages registry, and I'm delighted at our partnership since the very beginning, but we often work with denial, like the bank managers. We don't have the scripts, but we have those denials that we face because people have given up, people have had negative experience, people suffer from stereotypes. And why I mentioned the damages registry is because a lot of people say, well, it's still a long way out and there's still a lot of work to do to receive all of these documents, but we show them that it's extremely simple. We show them these very simple examples and we tell them that if you don't do it right now, you won't get nothing. But if you do it right now, there's still a chance you might get something. So what creates a higher likelihood, right? This is very simple principle about simple communications. It's not rocket science, not even closely. And in my opinion, these approaches, they can indicate that victim-based approaches are not something out of this world for the criminal justice system. Thank you so much. We have mentioned assistance to survivors and victims, different categories of survivors and victims, the policies, the approaches, the attempts. There's definitely a discussion of the non-repetition mechanisms. But we are talking about our agency at this point. When we're talking about trans in the IHL area, we are talking about Ukraine's agency to make sure that Ukraine is no longer just a testing field for mass war crimes, but instead is an entity that is able to openly and independently mention the need to change approaches or change interpretations. We have some time reserved for questions from the audience. So, colleagues, if you do have some questions, please. First and foremost, thank you so much for the panel. Secondly, I wanted to start by making a comment, not a question. A comment on the non-recurrence measures. This is something that can be interpreted quite differently because a nuclear strike can be perceived as a non-recurrence measure. And it will show that it is an effective measure, but not in the context of human rights, for sure. So my first question pertains to compensation mechanism. So, looking into the lessons learned from the Balkan conflict, from the war in the Balkans, and the attack launched by the Serbs against Bosnian settlements, my question is as follows. Have you looked into the experience of the compensation mechanisms they implemented? Because as far as I remember, there were at least 500,000 claims that were fulfilled eventually. So how were they fulfilled, right? Were there money? Were people ready? Or did it take years and years? Like in our case? Like Veronica mentioned, you could do something and wait for years, you could do nothing and still expect right, but for no reason. Thank you. Thank you. Thank you, Anton. Thank you for your question. The damages register has the council of the register, which is the key coordination body that ultimately makes decisions whether the claims are acceptable and should be included in the registry. Other than the conference of the participants, that includes all of the member states, the council includes key specialists on international law that have worked for many years in different compensation mechanisms, and one of the members of the council worked with 20 different compensation mechanisms. So the experience and lessons learned are colossal, and those are the key stakeholders in this arena, and no one in the world knows this mechanism better than they do. So we have studied that, we have taken best practices. I cannot tell you which mechanisms in existence before were most efficient, but Ukrainian situation is unique because our conflict is still ongoing, the war, right? The war. because international law mentions it as a conflict, but the conflict is still ongoing and the mechanism is already in place, right? The claims are being submitted. Usually the way it works is that the conflict came to a stop and then gradually the entire system was being stood up that accepts the claims, that registers the claims, considers the claims, allocates compensation, pays compensation. That all happens simultaneously. Usually. In our case, the faster, in order to make sure that we launch it as fast as possible, we started with accepting the claims. Another example of how that works, another great example of how that works, is the UN Compensation Commission on the Iraqi-Kuwait War, where there was an agreement of Iraq to compensate on these claims. And this commission worked for 31 years, and it ceased its operations in 2022, if I'm not mistaken. And all of these compensation mechanisms that exist or have existed before, they're concentrated in The Hague, the key compensation mechanisms, and the headquarters of the registry are also in The Hague. A lot of employees of our compensation registry have joined us from different other international mechanisms, so we have this institutional legacy and institutional experience on how to best implement these mechanisms. Thank you. So you have studied everything, implemented the best practices, and that's how we'll have the compensation committee. Okay. Are there any more questions, colleagues? Matveyev Marta, I hope you can hear me. Matveyev Marta, a student from the Ivan Franko Lviv National University, the law department. I have a question to Mihailo. You have touched on this topic, on the topic of compensation mechanism, compensation expenditures, and through my paradigm of student life, I could share with you that we are currently studying international private law, and a professor has told us a story where a Ukrainian farmer and entrepreneur has addressed the Gazprom to compensate losses on the many hectares of the fields lost as a result of the invasion, and the case eventually reached a regional Hague court, district Hague court, but because of the principle of alter ego, the Hague court said that they could not acknowledge their responsibility and their jurisdiction on adjudicating this course. So my question is whether there are any mechanisms implemented to use the frozen assets of the Russian Federation and the legal entities associated with the Russian Federation in terms of compensating damages to Ukraine and paying reparations to Ukraine. Honestly, I'm not even authorized to answer this question. Look, we have the right to protest. You have to take off your government hat, right? No, but so all of these situations related to different arbitrages, you should have asked the speaker at the previous panel still. But these conversations are being held in Ukraine, right? Because there is a convention on the protection of investments, and in that framework, Bank has taken to court Naftogaz and has won that case. Those cases are known to a lot of people. So there are these ideas to take Russia to court in different international jurisdictions, but it is very difficult to do. I know that other international jurisdictions are not willing to take on the responsibility to enforce those verdicts, and it is a challenge that exists in Ukraine as well when it comes to cases against the state of Russia in the national court system of Ukraine, because the tiny caveat in that is that any court verdict, if a country takes on a certain jurisdiction, every court verdict has to be implemented. So if there's no instrument to implement that verdict, then there's a question: does that satisfy the right to fair trial? There's a lot of Supreme Court case law, Supreme Court of Ukraine case law that is being actively discussed. There are a lot of issues that the experts are having with that case law. But the register itself, it operates in the framework of the international law. When it comes to assets, there's very little I can tell you, because even the official FAQ on the Compensation Commission of the Council of Europe mentions that this issue is being currently investigated. The frozen assets of the Russian Federation are something that is widely discussed through different contexts. Yesterday, someone mentioned the idea of using those assets to provide intermediary immediate reparations for the victims and witnesses through the government of Ukraine. But the real question here is what will the ultimate decision be, right? Our compensation mechanism has the highest chance of success because it is based on international law. There will be the convention, there soon will be the extended agreement. There is cohesion from more than 50 states. There's commitment from more than 50 states, but in reality, we don't know what is going to happen. There are no specific ideas. Yeah, but we had a specific idea in the 28-point peace plan what to do on frozen assets. So there are a lot of entities trying to do something with those assets. I have a question to finalize our discussion, to kind of draw it to a close. Going back to the beginning of today's discussion, there's currently a lot of work being done on the National Strategy of Human Rights, on updating the National Human Rights Strategy. Veronika's heart fluttered, right, twice, sure, because she's always there at those discussions and she knows how the process is taking place and which efforts are being taken. So for everything that we have mentioned today, all of that has to also be mentioned in the National Human Rights Strategy, ideally. So my question to you is, could you tell us what is the key idea, the key event, the key measure mentioned in the National Strategy of Human Rights, or if that strategy will be implemented in the Transitional Justice Strategy, how it should all that we discussed be reflected in those strategies? So the non-recurrence strategies, the measures taken by the government to counter the consequences of armed aggression. I will repeat myself, but I will mention a couple of measures, right? So the first and foremost are measures aimed at accounting for all of this information, because we currently don't account for everything. Since 2014, we haven't been doing that, but it goes for both accounting damages to non-material rights, non-property rights, but also accounting damages to property rights. There's no system like that. When we say that Russia has to pay for everything, what is that everything? How we calculated that? No, we have not. So the first is the damage, of course. So the damages to both non-property rights starting from February 19th, 2014, and for property rights. The damages to property rights that were located on the temporary occupied territories at the beginning of full-scale invasion. And that's the first thing. The second thing is the damage related to the pillage and seizing of the property on the temporary occupied territories. All of these damages have to be calculated and accounted for, as well as all of the expenditures accrued by Ukraine in terms of the support of victims. Because we are the first nation that has implemented intermediary compensation mechanisms in the time of war. The second thing that has to be done is defining a victim. What is a victim? What are their rights in terms of support that they should be provided? And the third measure that has to be mentioned is development of the comprehensive system that would take into account both the multiplied damage, because we know that a lot of civilian detainees, they have this multiplied damage. They usually suffer from torture, they usually suffer from CRSV. So there is this idea of multiplied damage which has to be taken into account. So accounting, identifying the definition, and developing a system of support. Thank you, Mikhailo. I put on my hat back, right? We would be delighted if the strategy could mention the need to raise awareness amongst victims and survivors on the possibility to submit claims to the registry, because it is the pathway to justice. Okay. Right. My colleagues mentioned a lot of different things, but from the viewpoint of governance experience, I want to mention a couple of things that are lacking. And the first thing, of course, is coordination, because human rights are a cross-cutting issue. And every government entity in Ukraine has their own role and has their own mission in terms of ensuring human rights. And this system that would allow to delineate the roles, the main role, the supporting role, it's really important. And in this coordination process, the individuals also play a huge part, because the system will work if there would be these agents of change that would push it forward. And I think it's extremely logical for me to also mention the second thing I would like that system to mention is awareness and education of the individuals who would be these change agents and who would ensure this process. Because very often the same person has many jobs, wears many hats, multifaceted hats, and you don't always have all the necessary competencies that the government demands from you in this specific case. So, coordination and internal awareness raising campaigns and competency raising campaigns for the individuals in charge. And to keep in mind that service members, both retired and active duty, are a huge category who are often victimized. So we have to also keep that in mind. And it is a special category. So, in the general mechanisms of compensation, there has to be a special place allocated for them. And sometimes they have to be treated in a special manner.
Thank you so much. So I would like to add to what my colleague has mentioned, because this interagency cooperation is very important. Now we're working with judges, prosecutors, healthcare professionals, especially in the context of the conflict-related sexual violence and gender-based sexual violence. And sometimes officials, judges, prosecutors are doing the good job, but they're doing that in parallel. That is why this interagency cooperation in the context of working with victims, supporting them, is of utmost importance, because it's going to contribute to the efficiency of the entire machine, and it's going to provide support for the victims, and it will also improve the image of public service. Maybe it sounds somewhat naive to you, but it is important, because the state needs to become visible so that the citizens can feel the support of the state, because state is not only about some structures, buildings, and facilities. It's people. It's people who are shaping policies. And in the context of awareness raising, I would like to also agree with you that it is very important to have as many as possible officials, judges, prosecutors, everyone who is enabling this cooperation have necessary powers and authority, and also to be competent in a proper way. So I truly believe in this training, lifelong training and lifelong learning. This is something that each and every one of us needs. We need to keep improving our professional competence. And I believe that human rights advocacy should become the personal competence of each and every single one of us. I think it should be instilled from the kindergarten age, because I believe that we are the state that is upholding these democracy principles globally. And I think that our practice actually is unparalleled. But, in all the strategies, organizing trainings is very important. That's why I think it's going to work out well. Okay? I would like to say that as a person who has spent hours on end working over this chapter, because the national strategy has the chapter dedicated to the war victims. And yeah, it also mentions training and awareness raising. It even mentions some things about international humanitarian law and many other things too, by the way. And as a person who has been dealing with all of this for quite some time now, the most important thing in the strategy for me is the plan of measures. Because, after you're done with developing the strategy, you have to get down to work and decide who's going to be responsible for that. And everything that has to do with how realistic the plans are, coordination, definitions, the direction that we're headed in is outlined in the plan of actions. Because what I see in the draft version of the strategy, in the chapters that have to do with the war victims, because there are many cross-sectoral things many things that are intersecting, because here we're talking about the rights of the servicemen and servicewomen. So, I believe that it's also important to focus on this cross-sectionality, because there are areas that can be improved. But I definitely want us to know, and again, Minister of Justice did an amazing job while working on that. And they are carefully listening to everything that we are discussing at every single meeting. So we have to also think about how we can implement it and how clear it's going to be for those who will be responsible for implementing that. And will it allow us to achieve all of the goals? Because I believe the strategy should be somewhat romantic. We have to look up to something amazing, and so that we can look up to something, expect something, and for the action plan to be very realistic, coordinated, something that can be properly implemented. Thank you so much. Well, as you can tell, we had very human-centric panel today. We talked about the victims and the state, very human-centered state. It is very important for us to say that we need to have a proper system for victim support. Now, in 2025, we should not divide people in different groups, those who were victims before 2022 and those who became victims after 2022. No, we should establish the support system that will allow person to bring back their agency and to cope with the consequences of those horrible events that they went through. I'd like to thank all of our speakers, and today here with us was Veronika Plotnikova, head of the Coordination Center for Victims and Witnesses Support of the PGO, Yulia Likhach, director of the High School of Public Governance, Inna Zavorotko, Department of Legal Support of the Ministry of Defense of Ukraine, Mikhailo Kamenev, Senior Project Specialist of the Register of Damages to Ukraine, and Ksenia Getz, head of the advocacy program, Right for Defense. And now I'd like to give the floor for the final remarks.